Okay, we're back with screencast number 2, going over the midterm. This is the short answer section. Provide a one-sentence definition for the legal concept of precedent. You guys did a pretty good job with this. The only thing I would have added to some of your language is that precedent is normally a ruling on an issue, on a similar or the same issue from a higher court. That precedent is when a higher court rules on something, the lower court is bound by precedent. Question 13, identify and describe 2 factors that a party might consider when evaluating whether or not to appeal a trial court. You guys did well here as well. A lot of you mentioned one obvious factor is, do you think that there was an error made at the trial court, an error of law or an error of fact that is worth appealing? Another part of that question is, was the error significant? Do you think the error would change the outcome of the verdict at the trial court? If you think there was an error made, but it's not, a huge life game changer, you might not appeal. Why? Because third factor is appeals are expensive. And if you don't think it's going to change the outcome, you might not spend the money to appeal. Fourth factor is depends on what you've lost. If you've lost, a chunk of change, but not a huge chunk of change, you might not appeal. If you've lost your freedom, or if you've lost millions of dollars, you might decide to appeal because those are much bigger losses and there's more at stake for you and you have less to lose if you appeal. That's why the appellate courts are often very crowded with inmates appealing their convictions. Why? Because they've lost their freedom. They've lost a lot and they have the time to file an appeal. And they have a huge incentive to do so because if they win the appeal, they would get out of jail, and that's a big motivating factor for a lot of people. Another possibility is maybe you just want to delay and run out the clock. If you're, if you're a place, if you're the government of the state of Texas and someone is suing you about a law that you put in place regarding, reproductive rights. You might appeal a ruling from the lower court to delay until maybe there's a new executive. Or if you're President Trump, for example, is appealing various rulings about him disclosing, communications and documents from his time in office, and he's delaying those because he thinks that perhaps after the midterm elections there'll be a new majority in Congress and these investigations will stop. So there are also strategic reasons why you might want to appeal. Question 16, describe briefly how the appointment of Justice Barrett shapes the dynamics of the Supreme Court. You guys did well here for the most part. One of you mentioned that Justice Barrett had gone to Notre Dame, which was a big deal because she's the only member of the court who hasn't gone to Harvard or Yale for law school. And that does change the dynamics. But in a larger sense, her appointment changes the dynamics because she replaces probably the most liberal justice, who was Ruth Bader Ginsburg. And she herself is a very conservative justice, and she gives the conservatives on the court a 6-3 majority, meaning that meaning that there isn't one swing vote. Kind of takes the swing vote out of the equation. There's no one justice who can really affect the outcome. Because there's a 6-3 majority. Even if Chief Justice Roberts decides to vote with the liberals on issues, it's still a 5-4 conservative majority. Justice Barrett is also very young. She's in her 50s, along with Justice Gorsuch and Justice Kavanaugh. These are 2 very young justices, and they'll be on the court for a very long time. And so she shapes the dynamics that way as well. Question 17, if you were to become a state court judge, what would you prefer? Would you prefer your position to be the result of an elective or an appointive? Why? And why would you be in favor of retention elections? Almost all of you wanted to be elected as judge. And many of you said that you thought that would make you more accountable because you'd be elected by the population that you were going to be judging. And that's a good reason. The other side of that argument, though, is that when you have to be elected, you have to win the majority of the voters, get their votes. And if you are, campaigning and saying, hey, vote for me because I'm going to do this, or vote for me because I share your values about X, or I share your values about anything, voting rights, gun rights, reproductive rights, liberty interests, privacy interests, then the people who don't vote for you are going to feel like they're not going to get a fair shake in your courtroom because they think that you have a bias towards the way you see things, and that your bias isn't in favor of the rule of law. Your bias is to reward the folks who voted for you. If you have to campaign and be elected, you might have to get campaign donations. And so, if Big Oil gives you $500,000 to do your campaign, or if the local coal company gives you $50,000 to put ads on TV, question whether or not people are going to trust your decisions when you're on the bench. When you're appointed, you're usually appointed, the way it works in most states, which of course, from your reading, is that most states have a system where the governor can appoint people, and or the governor will have a commission or a council that will put forward a list of appropriate or qualified candidates, people who have had high-level jobs, people who have been lawyers for a while, all kinds of things. And then the governor usually chooses from that list. And it's certainly the case that sometimes governors choose their buddies or they choose people for political reasons, but usually there's a list of qualified candidates who the governor then chooses from. And those qualified candidates don't have to campaign and they don't have to be elected. And then in those states, oftentimes you'll have a retention election system, which does give the population a chance to vote to keep the judge on the bench. So if there was a judge who was appointed who seemed to be a real political crony of the governor, a retention election would give the population an opportunity to decide whether to keep that judge or not. It's also true, however, that in most cases, when there's a retention election, it's unopposed. So it's not like you're running against somebody else. It's just whether or not they want to keep you. And most of the time, a judge on the bench will win that. So complicated stuff. Question 18, you are a 45-year-old litigation partner at a large Boston law firm. You have 2 children in middle school and a spouse with his or her own busy career. The governor nominates you to become a trial court judge. Do you accept it or not, and what are the factors? Well, again, there was really no wrong answer here, but I wanted to hear what you would think about. A lot of you thought about family. A lot of you think that a trial court judge in Massachusetts is going to make more than a litigation partner at a large Boston law firm. Well, I'm here to tell you that litigation partners at large Boston law firms are making 3, 4, 5, 10 times as much money as a trial court judge. So if you are a litigation partner at a Boston law firm and you're offered a job as a judge, you'll be taking a huge pay cut. Now, you might still do it because you'd have regular hours, maybe. You'd have a life, you'd have job security. You're on the bench. You're not going to be having to kind of go talk to clients all the time. You're not going to risk losing cases. You might not have the stress. It might be more stressful to be a litigation partner than it would be to be a judge. You have a chance to think about new skills and new things to learn, courtroom management. You get the prestige of being a judge. You get to know that your day ends, for the most part, your day probably ends around 4:30 or 5 o'clock, and then you do some work and go home. So there's a lot to think about. You might still want to be the partner because you're making a ton of money, and you might not want to be sitting in judgment on people in your community. You might not feel that that's what you want to do. So there are a lot of factors. Question 19. Describe ways in which an appellate court might compel lower courts and affected parties to implement the appellate court's rulings. What foundational principle of jurisprudence is implicated if a lower court fails to implement an appellate court's rulings? This one didn't get a lot of great answers. I mean, no one did terribly on it. But what I was asking in this question is, if an appellate court makes a ruling on appeal, how does it get the people or the lower court to actually implement that ruling? I mean, the appellate court doesn't have a police force. It doesn't have soldiers. It doesn't have tanks. It just says, hey, trial court, you were wrong about this, and therefore you need to change it. So how does the appellate court get the lower court to do that? Well, first of all, it tells them they were wrong, and it gives them the reasons for them being wrong. Then it might, if the lower court didn't want to do it, the appellate court might sanction the lower court, might issue monetary sanctions against the lower court, against the judge even. It might issue like a formal reprimand or rebuke against the judge. It might refer the judge at the trial level to, the administrative body that governs judges in that state. It might issue monetary sanctions against parties. It might issue subpoenas to require the parties to come to court. And if they don't come to court, they can be arrested. So there's various things that appellate courts can do to compel the lower courts to implement the rulings. And if the lower courts didn't, that would implicate, stare decisis, which a lot of you got, which is the same thing as precedent. Really, it's about the rule of law and the ways in which our court systems are set up. It's sort of like you can't have a rogue trial court. You can't have a trial court that just wants to do whatever it wants to. The appellate court has to have a way to keep those trial courts in line. And the ways it can do that are by sanctions, are by formal rebukes, or by other procedures that they can use to even disbar or impeach a judge who's going rogue. Question 20. In a dispute over a federal civil rights statute, the plaintiff is from Alabama, the defendant is from Georgia. Neither the plaintiff nor the defendant is a federal entity. Plaintiff's claim is valued at $68,000. Can the plaintiff bring suit in federal court, or must they sue in state court? Why or why not? This is kind of a tricky one. There are three bases for federal court jurisdiction. One of them is federal entity jurisdiction, where one party is a federal entity. If one party is a federal entity, then yes, they can sue in federal court. In this case, that does not exist because neither the plaintiff nor the defendant is a federal entity. So that's not a basis for getting to federal court. There are two other bases for getting into federal court. One of them is diversity, where the parties are from different states and the dispute is worth more than $75,000. So here, the parties are from different states, Alabama and Georgia, and the case is valued at $68,000. So diversity jurisdiction would not provide a jurisdictional basis for getting into federal court. What's the third basis for getting to federal court? It's where there's a federal question, where the law or the dispute at hand has to do with a federal law. In this case, it's a federal civil rights statute. It's, something like someone's civil rights are being violated pursuant to the federal law. And because there is a federal question in the case, there is a basis for the parties to go to federal court, whether or not they meet diversity jurisdiction, whether or not they're federal entities. If there's a federal question, like a federal civil rights dispute, they can go to federal court. And that's why the answer here is that they can bring suit in federal court. So that's it. Good work on the midterms. I hope you had a good break, and we'll talk this week.